Denise Smith-Klein. I'm filling in for her today and chairing this particular hearing. First order of business is to swear in our new member, Mr. Chuck Till, and Ralph's going to do that.
Let's see, let's do it this way. Since you have to use your left hand to put it down.
All right.
Left hand on the Bible, raise your right hand, please. You, Charles Till Jr., solemnly swear or affirm that you will support and maintain the Constitution and laws of the United States and the Constitution and laws of North Carolina and consistent therewith. You will faithfully discharge the duties of your office as a member of the Raleigh Civil Service Commission. So help you God.
I do.
Congratulations. Welcome to the commission.
Thank you.
Give you a chance.
Congratulations and welcome aboard, Chuck. Okay, I think the only item we have today is a hearing on the motion by the city to dismiss this matter. So absent any further business, we'll go ahead and just start with the city since this is your motion. Ms. Davis.
Thank you, Commissioner. Good morning. I'm Anna Davis with the Raleigh City Attorney's Office. As you know, we're here this morning on the city's motion to dismiss the appeal of Steve Martin. The city's position is that the commission lacks subject matter jurisdiction because Mr. Martin, the petitioner, did not appeal his discipline in time pursuant to Standard Operating Procedure, City of Raleigh 300-18. Mr. Martin's, the petitioner's appeal concerns discipline he received from internal affairs, but his attempted appeal of the discipline was untimely. He also did not appeal to the city manager's office. And so therefore, the city has moved to dismiss for lack of subject matter jurisdiction. So what is the commission's authority and jurisdiction? As you may know, the Civil Service Act defines the scope of the commission's authority and subject matter jurisdiction when acting as a grievance appeals board. In terms of your authority, the Civil Service Act authorizes the commission to affirm, modify, reverse, or as it deems necessary, those actions over which it has jurisdiction. Those areas of jurisdiction include suspensions, layoffs, removal, promotions, forfeiture of pay, or loss of time. The burden of proof to demonstrate that you have subject matter jurisdiction over the appeal falls on the petitioner, not on the city. And only those issues raised in the hearing request that's before you behind tab A are matters that may be considered by the commission. And so if it's not raised in the request for administrative hearing, it isn't properly before the commission. By way of background, petitioner is a sergeant with the Raleigh Police Department, and the Internal Affairs Unit in the department investigated petitioner's conduct due to some allegations throughout 2023 and 2024. And as a result of that investigation, they issued a suspension, a permanent ban from the take-home vehicle program, and a final written warning as discipline, and the dates are important here, on April 9th of 2024. On April 17th of 2024, petitioner notified then Deputy Chief Rico Boyce of his desire to appeal his discipline. The city's policy 300-18 outlines the steps that employees must take to properly appeal a matter from the department level to the city manager's office to this commission. And so before those other steps are taken, it's critical that employees follow step one. And in the policy, step one is outlined as follows. An employee shall appear directly to the department head in writing within 5 working days after the cause for the grievance occurred or became known to the employee. And it defines working days as Monday through Friday. As you can see on the request for administrative hearing at tab 1, the petitioner is on notice, all petitioners, anyone who chooses to request an administrative hearing is on notice that employees must pursue their grievance as required by Standard Procedure 300-18 before appealing to the commission. As you likely know, the policies that are adopted by the city are before the commission for approval at previous times. And so the steps outlined in 318 are the rules that have been accepted by the city and this commission. So just to give you a visual of the timing, on April 9th, Major Eric Goodwin of the Internal Affairs Unit issued the written discipline to the petitioner, and the petitioner accepted acknowledgement of that discipline on that date. The first working day is April 10th, the second, April 11th, the third, April 12th, the 15th is the 4th, and the final day for appeal would have been April the 16th. However, the petitioner did not appeal his discipline until April 17th, and therefore it was untimely. It was late. Petitioner knew it was late, and he admitted that it was late. If you look on it being the 6th day, he did not follow the provisions of 300-18. And if you look in the city's motion to dismiss in paragraph 19, there's an excerpt from the email that petitioner sent to then Deputy Chief Rico Boyce. So in paragraph 19, you'll see, on April 17th, petitioner sent an email to then Deputy Chief Boyce with the subject line, Notice of Intent to Appeal. But in the email, he acknowledged that it was untimely. He said, I just noticed this email was never sent and has been sitting in my folder. Sorry for the delay. And that you will also find at Exhibit 8 in now Chief Rico Boyce's declaration. In paragraph 20, you'll see that on April 17th, petitioner sent another email to Deputy Chief Boyce, again acknowledging that his appeal was not timely. He said, again, sorry for the delay, and claimed that in reality he had sent the email on Friday, April 12th. Pursuant to his claim that he sent it on April 12th, the department conducted another internal investigation with the IT department to determine when the email was sent. Through the declarations of John Maltzby, who handles the IT for the department, Sergeant Maltzby contacted also the city's ID department and requested a trace of this notice of appeal email. City IT confirmed that the email was not sent or received by Chief Boyce until April the 17th. So regardless of the date that the petitioner may have intended to give notice of appeal, he did not appeal it at a timely fashion. He asked this commission to reverse the department's decision. He asked you to change the findings from sustained of the violations of policy to proper conduct, and he asked you to rescind the discipline. The city's position is that is not properly before you, and importantly, if you look at the request for appeal hearing, he does not allege that the city violated SOP 300-18 related to the denial of his appeal for lack of timeliness. So he does not make that violation. And pursuant to the scope of your authority, the commission is limited to the issues that the petitioner has raised on appeal. The petitioner's appeal is never heard by the department head or by the city manager's office. And for those reasons, the city asks you to dismiss this appeal for lack of subject matter jurisdiction. Thank you.
Thank you. Any questions by the commission members before we see about a response?
Questions, if you don't mind.
Yes.
Well, first of all, Ms. Davis, thank you for being here and presenting to the commission. My first question is about jurisdiction. I believe one of your first slides also mentioned that. One of the areas of jurisdiction that this commission has is our suspensions, layoff, removal, promotions, forfeiture of pay, or loss of time. Could you help me make the connection? I don't see anywhere that says the following, time frames that the city stipulates as a basis for jurisdiction. Could you help me make that connection?
Sure. I'm sorry, I don't think I
Yeah,
follow.
no,
Yeah,
it's
yeah.
just in terms of the commission lacking, as you say, subject matter
Oh,
jurisdiction.
sure, yes. So since the commission's authority comes from SOP 300-18, it's the city's position and also is listed on the top of the administrative hearing that to confer jurisdiction on you to hear those matters, it must properly be before you by the employee following the steps that are outlined in 300-18. So the city's position is if step one isn't complied with, then it doesn't reach the commission because each of the steps are needed and necessary in order to confer jurisdiction onto the commission.
Okay. And in terms of SOP 300-18, so for section 4.3.3, under the section time limit, it also says employees must adhere strictly to the specified time limits for continuing an appeal to ensure prompt resolution of the problem. I guess my question here is, it doesn't necessarily say that, they must adhere strictly to the time frame or the specified time limits, period. It says for continuing an appeal to ensure prompt resolution of the problem. So I guess my question here is, does that not establish a reason for their, the employee's promptness in the process? It doesn't necessarily, if you will, it doesn't necessarily take away their jurisdiction in that matter.
The city's position is that there was no appeal perfected because the requirements of step one indicate that in order to perfect the appeal or to make the appeal viable, there must be notice to the department head within the time that was established by policy and approved by this commission.
Sorry for the continued questions. I'm just trying to wrap my head around this. My other question is in terms of, extenuating circumstances in this process, does the city SOP or the department's DOI allow for extenuating circumstances? For example, bereavement or, vacation for that matter?
There's no evidence that there was bereavement or vacation in this matter. sounds like you might be making an extenuated circumstance or fairness argument. I'd respectfully suggest that this commission doesn't sit as a court of equity and determine fairness or equities. And so whether something is equitable or not does not invoke the commission's authority and jurisdiction.
Okay. And one last question.
Please,
So
yeah.
sorry.
Yeah, no, thank you. Thank you for your questions.
In terms of the Civil Service Act, obviously the city's position, as I take it, is that the employee must exhaust all administrative remedies that are provided to them throughout the process. So is the city's position that they must go through all of the steps, or if you go to step 1, for example, and you can't continue beyond that step, would that not be considered also exhausting your efforts there?
Yes, it says Section 5 of the Civil Service Act says the commission shall have no jurisdiction to hear an appeal until all administrative remedies have been exhausted pursuant to the city's established grievance procedure. So as you pointed out, the petitioner did not exhaust his rights at the city level either, and exhaustion is required by the Civil Service Act. So there is no jurisdiction to hear an appeal until all administrative remedies have been exhausted.
Okay, I guess I'm just wondering, so would it not be considered that Mr. Martin, for example, exhausted all of his remedies available to him, considering he appealed, but, it didn't proceed from there on?
The 300-18 would require that the appeal then go to the city manager's office.
Got it. All right.
But he's not raised any violation of 300-18.
All right.
in
Thank you
his
so
request.
much. I yield.
Thank you, Mr. Lee.
Okay, we'll hear from petitioner. Oh, I'm sorry, Greg.
I apologize.
Oh,
Thank you,
no
Ms.
problem.
Davis.
Of course. Thank you.
Just following up a little bit. It said that you guys, that the Raleigh PD, Sergeant Maltzby did an investigation regarding the emails, and I asked the city IT. I noticed in the packet there was some, and I don't know if, in the packet it brought up allegations that a captain and a sergeant had the same issues of emails not being sent and then returning back to the draft folder. Was that followed up on through the city, a part of that investigation?
That was petitioner's statement. And so in response to his statement, RPD IT and city IT looked at the issues with his email. No other person, to my knowledge, said to Deputy Chief Boyce at that time, I'm having difficulty getting emails from you. And so that there was no other evidence other than the petitioner's statement about someone else potentially having a problem with their emails. That was not brought forward by those individuals to Deputy Chief Boyce. However, when he raised his concerns about his email and said, I'm telling you that I sent it on April the 12th, Internal Affairs, RPD IT, and City IT did an extensive dive into the statements that he was making to determine whether or not those emails were sent at the time that he said they were sent. And there was no evidence that it was sent on that date. And I'd point out to you his statements at paragraphs 19 and paragraphs 20 of the city's motion to dismiss, where he acknowledged, I know this is late. I'm sorry for the delay. I know this is late. If he had, in fact, sent them on the 12th, what would the need for the apology be, would be the city's position. So to specifically answer your question, there was no other evidence other than his statement that anybody was having difficulty receiving emails on the relevant dates.
So following up on that, if there was no evidence that that happened with his email, but the city followed up on the statement of his statement saying he had a problem with his email, and it may not just be mine, there's other people and supervisors are having the same issue, but
I
it was
think-
all made with during that
I think
same
what I'm,
process.
oh, sorry, I didn't mean to cut you off,
No,
Mr.
you're fine.
Haynes. Sorry. Were you finished with your question?
And it was brought up around the same time saying, hey, I'm having this issue. This is not I don't have that much knowledge about it. And I'm hearing it's happened to other people. So in the best interest of being extremely thorough, saying, could this be a computer glitch? Could this be something, the city, is this happening to other people? Sometimes it could happen, could fix. I just wondering why they didn't sort of look into that to be 100% thorough.
The investigation that they conducted was very thorough. Again, this was a petitioner, and this is my statement, a self-serving statement that other people were experiencing difficulty, but there was no evidence that anyone else was experiencing any IT issues, and no one came forward during the relevant time to say, yes, I'm also experiencing any issues. It was extremely thorough, and that the timing of his attempted appeal was very important. And so it was thorough in an investigation of when he sent his email, when it was created, whether or not IT could tell if it was in his draft. And so that was extremely thorough, extremely vetted. In addition, if he had believed that the email was timely sent, the apologies for the lateness do not, conform with his earlier statement that there were issues.
If I remember right, there was something about a statement regarding I'm sorry, it's late, that previous to that, he said, I was waiting on a response. And then I looked and I saw this was kicked back into my draft. So he's saying, I'm waiting on a response from Chief Deputy Rico Boyce. Would that also not indicate to the city that he's waiting on a response, that something had been sent to get a response from, and then when someone realizes it's in a draft and may not have been sent, hey, I'm sorry. So looking at it in the totality, all the statements put together for the full statement, instead of taking bits and pieces out and only using that, did the city consider both those together instead of just saying I was 6 hours, 25 minutes, and 13 seconds late?
The city did consider that, and the rules require that the notice of appeal be sent within 5 working days. The evidence before the department was that the notice of intent was delivered to Deputy Chief Boyce late.
Okay. Has the city ever given a waiver for missed deadlines in cases being appealed?
I can't say if the city ever has given a waiver. I can't say whether they've given a waiver, but I do know that the position of my office is that the requirements of 300-18 need to be followed, and they are the commission's approved rules. Since I have been in the seat for 2 years, I'm not aware of any waiver. I'm not aware of any other timeliness issues where any other employee has failed to meet the deadline. For me, and the number of grievances and appeals that I've handled in the last 2 years, all of their employees have timely appealed.
All right, thank you, ma'am.
Yes, thank you, Mr. Haynes.
Okay, petitioner? Oh, sorry, Trish, I'm sorry.
So, good morning, Ms.
Good morning,
Anderson.
Ms.
Thank you for
Holland.
being here. Something that I'm just not clear about, when I read through the materials, I saw what you're referring to as the April 17 email saying, I just noticed this email was never sent, and has been sitting in my draft folder. Sorry for the delay. And now you're saying that on April 17, and maybe I just missed it, or April 12th, he said that he had sent it, and was he revoking what he said on the email of April 17?
No,
Or what?
he is, my understanding is that he is saying that he created a draft on the 12th and that it sat in his inbox.
Okay.
And that he realized on the 17th that it was in his inbox.
Oh, okay.
But that it was never sent. And so the city's IT investigation, they weren't able to tell the moment that the draft was created. That was not possible. But they were able to show that Deputy Chief Boyce received other emails that petitioner sent on April 12th. And they were able to confirm that petitioner sent other emails to Deputy Chief Boyce on April 12th. So stated more plainly, there was email traffic between Deputy Chief Boyce and the petitioner on April the 12th.
Okay.
And then on April 17th, his statement was that it was created and then it was in his inbox, or excuse me, outbox until the 17th.
Okay, thank you
Thank you, Ms.
for the
Holland.
clarification.
Thank you.
Yes, ma'am.
Is there reference in here, documents in here that are related to what you just said, that there is evidence of other emails occurring between?
Yes, ma'am. If you look at the declaration of now Chief Boyce, which is at, pardon me one moment.
I was just having a hard time finding it, I'm sorry. Maybe
Yes,
you
ma'am.
can-
If you
Asking for your help.
look at the declaration in Exhibit A and Exhibit 8 and Exhibit 9. And so I can tell you that in Exhibit 8, which is the declaration of Rico Boyce, at paragraph 7, excuse me, I'll back up to paragraph 6. In Chief Boyce's declaration at paragraph 6, he said, "I did not receive notice of Sergeant Martin's intent to appeal Major Goodwin's decision between April 9 and April 16th. He said, on April 12th, I received 2 emails from Sergeant Martin which were unrelated to his issued discipline or to his appeal. Sergeant Martin sent me an email with the subject line, missing extended mag at 7:44 a.m., and another email about the shift log at 5:15. Chief Boyce says, both emails appeared in my inbox on April 12th, and I did not experience any technical difficulty accessing either email on April the 12th. And so those are Chief Boyce's statements as it pertains to the email traffic, which was verified by IT at the time.
Thank you,
Yes,
that
ma'am.
was going to be my next question, thank you.
Yes, ma'am. Thank you for your question, Ms. Ball.
Why don't we hear from the petitioner? And then we'll come back. If you like, or you can stay there, either way, whatever's more convenient for you.
Probably easier to sit everything here. Set up there and that. Good morning. My name is Lee Turner. I'm an attorney here on behalf of Sergeant Martin. And I appreciate the time you've given us this morning to address this issue. We're here today on the respondent's motion to dismiss. And the purpose of this commission, if you look at the city's website, in very simple terms, is to hear appeals from city employees who have exhausted all administrative channels. This motion to dismiss by the city is trying to prevent that function of this commission. It is what I would call a hair-splitting motion to dismiss. If you look at this disciplinary process, it relies on the fact that this commission is truly the only completely neutral body throughout the entire disciplinary process. Because as it goes through the process that Ms. Davis has outlined through the department, you're still dealing with department heads, you're still dealing with department individuals, you're still dealing with individuals that all work under the chief. You are the first body where this is completely neutral with no obligations to anyone else in this department, no history with anyone else in this department. And not to say that the department's not fair, but this is the one body that is completely neutral. Here's the facts and makes a determination. Otherwise, this process goes through the same channels that basically discipline the officer. It goes right back through those same processes. So if you look at this today, and I'll address some of the questions you asked to Ms. Davis when I complete my presentation. I don't have a PowerPoint presentation for you. I'm not going to recite the rules to you, but I am going to dig more into the facts of this that weren't given during that presentation. As you know, you have a sergeant here today, 25 years experience on the department. 25 years of duty. He's worked all sides of this town. I think if you ask anybody that works under him, he's a very dedicated sergeant to his men. He stands up for them. Talking to him and hearing the things that occurred during the riots of 2020 and what they were put through, this is a sergeant that's given 25 years of his life to the city. He's dedicated himself to it. And he does feel that what happened with him was unfair. And he does want the things that Ms. Davis has asked for this commission to do. And he wants to be heard. If you look at all the documents you've been given, we're talking about, as Mr. Haynes said, a few hours of time. But we shouldn't even be looking at that, because if you look at the original the email that Chief Boyce received, first of all, let's back up. She showed you the calendar. April 9th is the date he received his discipline. And we know that the 5 days are 5 working days, which she said would have given him until April 16th, which would be midnight on April 16th, to request an appeal. Sergeant Martin was on duty earlier the week before, and his last day of duty was April the 12th, that Friday. During the course of that day, he prepared an appeal, believed it had been sent, went on about his work, did his shift. The 2 emails that Ms. Davis spoke of, they're not emails that are individually sent to the chief. They're emails the chief received because it's part of an email chain. There's shift logs, and then an email that was sent out concerning the missing magazine. They were sent to everyone. That wasn't just an email sent directly to the chief as a single person. So even though it shows at some point in time that was working, that the email system was working, that his computer generated an email and sent it out, it doesn't mean that at the moment that the email was sent on Friday to Deputy Chief Boyce at the time, that it went through. How many people in this room text? How many times have you sent a text to a family member, one of your children or whatever, and they respond back and, hours later, hey, why didn't you answer my question? And you look down, and on your phone it's, not delivered, the little red bar over to the side. You thought you'd answered. You thought you'd sent it. It didn't go through. The facts here that weren't relayed to you is that the 12th, the date that Sergeant Martin says he sent the email, was the last day of his shift. The 17th, that morning at 5:33, was his first day back at work. So he gets there early. He's there at 5:30. While he's there, he receives the notification from the captain that this is the day you start your suspension. That's what caused him to look back into the computer to see where the email was sitting in as a draft. So as he's doing that, he immediately resends that to Deputy Chief Boyce. And one of the things to look at in Boyce's declaration in particular, I believe it's declaration number 3. It's Exhibit 8, but then you brought them broken down into 1, 2, 3 different exhibits. It says Boyce Declaration 3. And you can see that that was sent by Sergeant Martin at 5:53 a.m. Literally, you know, 5 hours and 54 minutes past the deadline, even on that morning. And so then in number 4 of Boyce's declarations, you'll see that he responded to it that morning, Deputy Chief Boyce did, at 6:51 a.m., letting him know that he didn't receive it on that Friday. And one of the things, if you look at those emails that was sent, in particular, let's go back to number 3 of Boyce's declaration. In the last line of that, looking at the context of the email itself, it says, "I appreciate your understanding. Have a great weekend." So that's one of the things that nobody's brought out this morning, is the fact that even the context of the appeal indicates that it would have been sent on a Friday or the week earlier. He's telling it, would you tell someone to have a great weekend on Wednesday morning? So all this is just where that was discovered and sent to the chief. And so if you look at the timeline, that it just doesn't make any sense that it would be worded that way unless you're just thinking this sergeant is that, I don't know what word to use, that nefarious, that he would go in and change the whole wording of it, or make up this wording to indicate that he did it on Friday. Why wouldn't he have done it where I did it on the 16th if he's going to make up an email and say it didn't send? None of this makes any sense. It doesn't, it just defies logic when you look at the wording and the timing of all of this. So being his first day back at work, he responds to it immediately, and you know, it doesn't say, "I never sent it." He said, "I just noticed this email never sent and has been sitting in my draft folder. Sorry for the delay." So that's not an apology for filing it late. That's merely just explaining that this was sitting in a folder and it never sent. That I did it, it just never sent. So you've got to, if you're looking at this, you can't just gloss over some rules and some timelines. You've got to look at the facts. So once that was done, Chief Boyce ordered an IT review. And in following through with the IT review, if you'll look, and I don't know if it's in this book that I had before me, but in the, I didn't see it in the book before me, but in the actual motion to dismiss, there is an Exhibit 9, which is the declaration of Sergeant Maltsby that she spoke of earlier. And in that declaration, it does say that I conducted a review of Sergeant Martin's Outlook account, determined he sent 13 emails between the 12th and the 14th. I was able to confirm that the email notice of intent to appeal was not sent to DC Boyce until April 17th. Okay, given that's the day that Chief Boyce actually got it. Was that the day it was attempted to be sent? I'd argue not. Then it goes on to say in paragraph 5 of that same declaration by Sergeant Maltsby, for confirmation, I contacted Joseph McCardle in the city's IT department and requested a trace of the notice of intent to appeal. We were not able to determine when the email was created as a draft or when it was in the draft folder, but again, McCardle confirmed the email was not sent or received until April 17th. So they couldn't even, through their IT department, determine how long it had been sitting in that draft folder. So again, we question a 25-year sergeant of 25 years credibility, that he's making all this up, or do we give the benefit of the doubt to a computer system that, according to other supervisors on the department, had flaws, and they were having problems? So that's kind of the timeline I would present to you, and some other issues. But the email itself was having issues. And one of the things I found very curious when I was going through all of this last week was your own policy as to appeals to this commission requires a specific form. It has to be written. It has to be delivered to the city clerk's office. It has to be time-stamped. There's a copy of that in there as well. That would prevent all of this. If the city did it that way, I was a policeman for 10 years with the Raleigh Police Department. If we appealed something, you had to take it it had to be stamped in, delivered to the administrative person, and that would prevent this type of problem. You, through your wisdom, has already prevented that because everything has to be submitted in writing. A specific form has to be used instead of an email. So I would say that the system itself is flawed in that we can let a computer dictate a career by 5 hours and 34 minutes, when in fact, you've got a sergeant that's telling you, I sent it well within the timelines. I sent it on February the 12th. So that would have been an alternative that would have solved this problem. And again, I refer back to the fact that it's not a fact that he didn't send it, that it did not send itself after he had attempted to perfect his appeal. All Sergeant Martin is asking of you today is to deny this motion to dismiss, and I assume that since he has not gone through the appeals process completely with the city, remand or whatever term you would use, that this goes back to the police department for him to finalize every administrative remedy he has there, going through the deputy chief's office and then to the city manager, and then if necessary, back to this commission. That is what we're arguing is the appropriate remedy for Sergeant Martin. Not to cut him off here, prevent this from being heard. He does have issues with this. That's not something we'll get into today because what we're dealing with today is something very narrowly tailored. But we would argue that, in fact, there was a timely filing of this attempted by Sergeant Martin. A computer caused a problem, a computer which was causing other problems, and in turn, this was not received until Sergeant Martin was given notice that you're suspended starting today. Oh, what happened? Let me look and see. Oh, it's sitting in my draft folder. Let me send it right now and tell him I'm sorry for the delay. So there you have it. When you look at some of the questions that were asked, Ms. Davis made a statement that this is not a court of, every court that I appear before of is a court of equity. Equity plays into every judgment a judge makes, whether it be for a speeding ticket or this commission or a homicide. Equity comes into every single decision that's made. And is this equitable for this appeal to be thwarted when there's definitely an issue with whether or not this untimely filing is accurate? When you look at some of the questions that were asked by the members here, I would argue that it was not extremely thorough as far as the investigation goes, and that Sergeant Martin brought up these other supervisors that had problems who were never interviewed by HR when that was presented to them as well. And so we don't know the situation. You don't have before you the problems they had. It got to the point where it's my understanding that one supervisor actually told subordinates not to email him because of the problems he was having. And we don't have any of that in this motion to dismiss. So if you want to cherry pick the rules and cherry pick the facts, as the city would have you do, then you will see this was technically received by Deputy Chief Boyce 5.5 hours late. If you want to get into the weeds and look at the facts and apply your common sense to it, what the city's proposing doesn't make any sense, and what you're doing, if you allow this motion, is you're basically discrediting everything this sergeant of 25 years is telling you. And you're also just eliminating your common sense. We pointed out the text of the appeal. Have a great weekend. I did it on the 12th. He could have said, I did it any other day. It makes sense he did it on the 12th. That was his last day of duty before he went out and had his days off. It makes sense why it got filed that morning. He comes in, Captain, why are you here? This is your first day of suspension. No, I appealed. You look, oh, there it is. Sorry, I'll send it to him right now at 5:33 a.m. So these things, as a totality, as Mr. Haynes said, looking at it as a totality, this is very concerning that we are going to allow an appeal to be dismissed, legitimate concerns to not be heard over and take the credit of a computer system over an officer. And I'll be open to any questions you may have or anything I can assist with.
Any questions for Mr. Turner by commission members? If not, Ms. Davis would like to.
Yes, please. Mr. Turner and I have been colleagues for a long time, and I certainly respect him very much. He made a lot of good statements today that I'm hearing for the first time. That is because petitioner never replied to the city's motion to dismiss. Certainly some arguments were made about statements supervisors may have made about not using emails at any other time. The city's had no opportunity to research or identify some of the statements that Mr. Turner has made. And it is true that the commission is not a court of equity. Whether or not something is fair or unfair doesn't invoke the commission's jurisdiction. And so for those reasons, again, right or wrong, the commission is limited to what the petitioner raises in his hearing request. And what we're hearing today from petitioner is that perhaps the policy 300-18 is imperfect and we shouldn't be using email, or none of those things are properly before the commission at this time. The only thing that is proper for the commission to consider is what is raised in his request for hearing. There may be other avenues for Sergeant Martin to explore changes that he might be interested in suggesting down the road. But as it stands, these are the parameters and the guidelines that the city is following through 318 and what the commission is bound to at this present time. I'd ask that you dismiss the petitioner's motion, grant the city's motion to dismiss. Thank you.
Could I be heard for just 1 second?
Certainly.
Sergeant Martin did express these concerns to city personnel, including HR. And Ms. Davis wants this to be limited to what the sergeant filed. However, the other courtroom, the city, in doing this, filed a very detailed motion to dismiss, which opens the door for Sergeant Martin and myself to address any statement, any exhibit, anything that's in that motion to dismiss. Being so detailed and so thorough with all the exhibits and attachments, anything within that motion to dismiss is fair game for you to consider this morning, which I don't think anything I brought up in any way is outside of the realm of that motion to dismiss. So there are more than just a very brief appeal sent in by a sergeant that you can consider today. Not just that, but that motion to dismiss and everything contained within it.
I have a question for Ms. Davis then. What is the city's position, for example, if the commission today was to deny this motion? Now, where does that leave us? Because now we don't have a case to hear. I don't think we have remand authority as I read the Civil Service Act. So where does that leave us?
If you were to deny the city's motion, the city's position would be that the department head would I
Well,
mean, even,
That's why I'm
even
at,
if you denied it on this basis, there's still the issue of the lack of exhaustion that's required by the Civil Service Act.
oh, I agree with that, but that's why I'm saying, though, if the city denies the city's motion, if the commission denies the city's motion, will he still have the ability to get back into the regular appeal process?
If the commission denies the city's motion, that seems like the most likely outcome. I'm not sure what other remedy, if you will, there would be except to do that.
All right, questions from, I want to thank both counsel. You've done an excellent job presenting your various cases here in arguments. Just go around the table here and get the feelings of the rest of the commissioners.
Mr. McCormick, may I ask a question of the,
Certainly.
Mr. Leonard, was it possible for Sergeant Martin to access his email
We need to,
from the time,
we need to swear him in as a witness if he's going to take testimony.
Are you asking me? Or are you asking him? Sir, I'm sorry, I didn't mean to
He
interrupt.
asked Mr. Martin, so I'm saying we need to, if Mr. Martin's going to respond, I think we need to swear him in. Is that why you're?
all right.
So if you want him to testify, Ralph, you'll have to swear him in.
I see you over there. Where the Bible is, right there? Okay. You swear that the testimony you're about to give to be the truth, the whole truth, nothing but the truth?
I do.
Sergeant Martin, did you have access to your email from the time that you went off duty on the 12th until the time you returned to duty on the 17th?
I did.
And what type of access was that?
I mean, I can access it. Sorry. I can access it through my home computer.
And did you access it during that time?
I did not. There's a reason for that.
State it.
Deputy Chief Boyce at the time, my wife actually told me to follow up with him because I hadn't heard from him. Deputy Chief is very busy. I know him personally. I knew he would take the time needed, or at least I assumed it, and I figured he would get back to me in a timely fashion. I had no reason to believe he would not. So I wasn't going to send a follow-up and bug him. As far as my email, I was in my email. I don't specifically remember, but I'm sure I was in it at some point, and I never saw that in drafts. I didn't see it until the morning I came in and was told I had to start my suspension. And then I was like, what is going on? Like, I'm still waiting for Deputy Chief Boyce. That's when this whole process starts.
All right. The other question I have is, are there no affidavits from the other individuals who you indicate experienced problems with your email during the period in question?
So after this is Wednesday, I think. Wednesday morning, I'm now being told you have no appeal. Like Mr. Turner said, we have issues with the investigation. That's to be dealt with. But I felt very strongly about my investigation, very strongly, or about my appeal. So I was immediately stressed out because in my mind, I wanted my day in court, for lack of a better term. So I don't get stressed very often. I know I'm outside of the realm of the question here, but I'm a pretty laid-back guy. I've dealt with a lot of stuff, and I feel very confident. I felt almost like I was having a panic attack, so I called Doc E, our psychologist, and I was like, can we meet? When I went to the Northeast Station, their captain is Captain McKenna. I've known him for years. So when I left Doc Erickson's office, I went in there just to vent, because I'm still like just reeling over what's now been told to me that my email wasn't sent on Friday. And he tells me, well, that's funny. I'm literally going through the exact same thing, except he was the other side of it. He was being told from the command staff that he was sent an email and he never received it. And they had gone back and forth about this particular email. Now, mind you, he's still receiving other emails, but it's one email in particular that the command staff was telling him he got, and he's telling them he didn't get it. And so I was like, all right? I don't have a recourse with the department at this point. They've said, no, you're out. So I called HR, and I told HR, it's not in our common practice for me to have a captain write me something that says this is what I'm going through. So I went to HR and I said, I have a captain and a sergeant right now going through email issues. And she said, I will absolutely talk to them, give me their names, and it's my opinion that your appeal should hold because this doesn't sound right. She told that to my face. We had a face-to-face meeting. So when I left my meeting with her, I felt very confident. She's going to call a sergeant. She's going to call a captain. They're going to say, yeah, we're having issues too. Excuse me. I'm not an IT guy. I don't do IT. I do police work. I know I sent the email, and now I have 2 other people that are they're in similar situations. So I figured, okay. And they were never contacted. HR, why didn't you contact them? Never even got a response. All of a sudden, I'm out. I get no contact back from HR. So here's where we
No
are.
further questions.
Okay, you want to cross-examine? There's some hearsay in that testimony there. I don't know if you want to.
Yes, I do
Talk about
want to
that.
object during his statement, but I do object to any statement that his wife may have made, that Dr. Erickson with the department may have made, object to any statements of Captain McKenna. Sergeant Martin is represented. There would have been an opportunity to reply to the city's motion and include declarations of affidavits to verify independently all the things that he is saying, and they could have been submitted to this commission and properly considered at this time. So I do object to all of the hearsay that was introduced.
Okay, we'll note those objections for the record. Craig?
Looking at the packet that we received, Mr. Martin, Sergeant Martin, Ms. Ford, is she the HR person? The email is dated April 29th, 2024, from you to Ms. Tiffany Ford.
Correct.
Is that
She's
the HR person that you
representative
were
for the police
talking to?
department. Yes.
She is present. I want you to be aware of that. She is present.
And did you, I see that there was an email that you sent. Was there an email? Did you receive an email response or?
From her?
Yes.
I think initially we talked, we emailed, then we talked by phone, then we physically met. And then there was an email back and forth from her. One was saying, pretty much echoed what Deputy Chief Boyce at the time said, like, IT looked into your email, there is no appeal. There wasn't any more, I don't know, cordial back and forth. It was just kind of, that's it.
Thank you, sir. I see the follow-up email from Ms. Ford on 5-1.
Okay. There are no further questions from commission members.
May I?
Yes.
Mr. Martin, you were represented by an attorney immediately upon this proposed suspension?
No.
Okay.
I started the appeal process, was told no. I contacted my representation and said, what do I do now? And they're like, go to the commission. So there's a very standardized form you're supposed to fill out. I filled it out. There, like I said before, there is no recourse back to the city at that point. I have to, they've said I don't have a process. So I send it to the commission, and I wait to be called.
Okay.
And that initially, in the packet, that was lost. I sent it certified mail, and they lost it. 5 months later, I called, and I'm like, what's going on? Like, we don't have it.
So at any point, were you advised that it would be wise to have a declaration by these other people that you were told were having problems with, also with receiving and sending emails?
No.
This probably is not a question for you. I'm wondering if there should have been some information you were provided about that from HR or from your attorney or whatever, but that may not be a comment that, I don't know.
The only
Attorney can-
point at which I was told I should have representation was when I went back to the city to refile it the second time, when I found out it was signed for, and then who knows where it went. And I was told, or I was asked, do you have representation? And at that point, I had already contacted Mr. Turner because things were looking suspicious on a bunch of different levels. Not to say anything nefarious is going on, but it just didn't look right. So I had already contacted him at that point. But that was at the point at which I'm filing with civil service, which I believe to be my only remedy at that point, because the city said, we're done.
But at that point, you didn't seek to get any documentation of these other instances of problems with emails that others had?
No, because at that time, the city had no motion. So I just figured I was coming before the commission to present my appeal. I didn't know. We're in a weird area, you know, like I had not exhausted ahead because the city said I didn't have any more process, but I was just reaching out for some entity that could hear my case. And the city said no, so that was going to come to you at this point. And so, no, I wasn't getting the affidavit yet because there was no motion by the city to dismiss. So I didn't feel I needed to justify that or to verify or prove that person's statement, I guess is what I'm saying.
Thank you.
You're welcome.
Any more questions before we close the hearing, and then we can deliberate? Okay, if not, I'll declare this hearing closed, and then we'll open the floor for the commissioners for their thoughts. I hope everybody will remember that we're facing a conundrum here that we often do with this body, in that we're very limited in what we can do, what our jurisdiction is, and what the available remedies for us are. This case, on its face, is very simple. There's a deadline wasn't met, so there's no doubt about that. And we don't have any equitable authority. Mr. Turner made an eloquent argument that perhaps we do, but we really don't. And you know, that comes up almost every time we hear one of these cases, because it's something we'd like to do, but we really can't do. So with that background, Ms. Holland, we start with you.
Sergeant Martin, I am very sorry that you're in this position, and I commend you for your 25 years of service. I am troubled by the fact that there are no affidavits from anyone else saying that there was a similar sort of trouble receiving emails. And I'm also troubled by I feel like our hands are kind of tied, because there is no evidence that I'm hearing of other waivers of timeliness, and I feel like we would be being inconsistent if we were to allow a waiver here and then deny it to other people, and I worry about setting a precedent. So those are my thoughts.
Ms. Ball?
Thank you, Mr. Chair. I was thinking as you were speaking, those would be my words, that I've sat on this commission for many years and have frequently felt as if by the way our commission is structured and the legislation that describes it and limits it, we are very limited in what we can do. Like Commissioner here, that's why I asked you the questions I did, that did anyone advise you to get affidavits? Because we don't see any of that. It's not questioning you or your attorney's veracity, but just we have to look at what's here. And I don't know how to fix that at this point, because we're here to answer one petition, and I am troubled that you were not aware that that might have helped you. Had you had that in your whole pleadings, it's mentioned, but it was not evidence that evidently Mr. Turner, correct?
Yes, ma'am.
Thank you. He mentioned it in his statements, but there's no evidence that there's those people's thoughts and situations were documented, so. And like Mr. Chair here, the question of equity has come up before. What might seem fair has come up before in many of the things that I've heard here. And I've even thought that we should probably proceed to get that further described as to what our limitations were or weren't, so. Thank you.
Mr. Lee?
Yeah, well, first of all, Mr. Martin, counsel on both sides. Oh. Yeah, first of all, Mr. Martin, counsel on both sides, thank you for being here today, and Mr. Martin in particular, thank you for your 25 years of service and to the city. But, you know, I really believe that, you know, while Mr. Martin missed the 5-day internal appeal deadline, technically, that should not automatically invalidate the process and his grievance. I mean, it's quite apparent that to me that Mr. Martin made a good faith attempt to appeal and follow up along through this intricate process. And, you know, a single day delay, which I feel Mr. Martin has, or not even a single day delay, you know, 5.5 hours, 6 hours delay, should not preclude his right to go through that appeals process. So, especially when it comes to a matter as serious as a suspension. So, you know, I'm inclined to vote to reject this motion, and ultimately, as the city attorney mentioned, you know, have this go back to the department head and follow through from there. Thank you.
Yeah, I'd also like to second that statement. And also the fact that there was talk about no affidavit. There was 2 emails sent, one on 4/29/24, and another one sent back from HR on 5/1 that also did bring up the issue of Captain McKenna and another sergeant that may have this. The affidavit or declaration of Sergeant John Maltzby is signed on the 29th of October, which is several months after the city is aware of an allegation that there might be other situations similar to this. And the city brought up distinctly that there was no issues with Mr. Martin's, but they didn't look into the fact that during that time an issue that there might have been possibility. So there leaves reasonable doubt whether it was as thorough as it could have been with the knowledge the city had. And I don't think there's no bright line rule, as in where you would say, with these facts, no. Yes, technically, are we past this? But there's always extenuating circumstances, and that we have to look at too. And would dismissing this, the city's motion, substantially hurt either side's case? It doesn't really go into the facts of the case. It's just whether it should be heard or where it goes from here. And the city did say that even though they asked for, if the commission dismisses their motion, that they would ask for extension to, did not see that? Is that, I thought I saw something for their extension. So where it goes from there, you know, that's outside the commission's, I guess, purview. But I would be, with all the facts that were in the packet, may not have been addressed verbally by either side, but it was submitted in the packet, I would be leaning towards voting to dismiss.
As a new member of the commission, this is an interesting way to begin. I want to circle back to the question of who has the burden of proof. What I've heard, in my mind, does not establish beyond a preponderance that the email, in fact, was sent on the 12th. And in the absence of that type of evidence, I personally have to conclude that the appeal was not timely.
All right. Well, having listened to the comments by everyone, I would just go ahead and put a motion forward that we go ahead and approve the motion to dismiss.
I do not agree.
Okay?
While I've previously said the things I said, on balance, I feel that there was testimony here that was not refuted in any way that I heard, that would not have been something that could have been considered had Mr. Martin made sure it happened and there was no advice given to him. So given that, I err on the side of giving him that opportunity.
What opportunity are you giving him?
That we are not going to accept the motion to dismiss by the city. Therefore, he has whatever recourse happens after that.
Okay. Well, I did not get a second on my motion, so.
I thought you were putting it to the vote. I'm sorry, was that's supposed to be a second?
Well, but we'll go ahead and vote. We'll vote on my suggestion that we grant the city's motion to dismiss. So go down the table. Alan?
I vote in favor of the motion to dismiss.
Okay, and you are against?
Against, yes.
I'm for.
Against.
Against.
For.
Okay, we are tied. So I don't know what to do about that.
Does our require, that what we're allowed to do not indicate what happens when there's a tie?
Nope, because we normally don't have a tie. Normally, we don't.
That's why we have
Normally, we're not hearing.
another member present, yeah.
We're normally not hearing motions, but, so if this is dismissed, I think the end result is it goes back to the city. The city will then either decide to allow him to go through the process starting all over, or we'll be back here again at some point soon, so.
Mr. Chair, I'm under the impression that in the event of ties, the motion would fail. Is
I
that?
think that's right. That's what I'm saying.
Okay.
Yeah.
So therefore, we return it to the city for their
Yes.
action.
Now, at some point, the city will still have to resolve those issues about jurisdiction and timeliness, and whether or not you will be able to proceed beyond the department to the city manager's office and so forth. So,
Does that mean that that Sergeant would have an opportunity to get some affidavits from people saying that they similarly did not receive emails during this timeframe? Is the
I suppose
record open?
I suppose either party can get all the affidavits they want, but by the time this comes back to the commission, I think we would want sworn testimony with in-person witnesses here, so they can be cross-examined. It's hard to cross-examine these affidavits.
Okay.
All right, then, we'll close this, and the effect of the vote is that the city's motion is denied.
Thank you.
The time on the monitor is 10:16 a.m. We are now off the record. So, question, are all the names that were mentioned during testimony today, are all those listed in the exhibits?
I believe so.